Well, thank you very much for having me today. My name is Vivek Sankaran. I'm the director of the Child Advocacy Law Clinic at the University of Michigan Law School. Our clinic represents parents, children, and foster parents in child welfare cases. And so I've been doing this work for more than 15 years now. And what I want to talk to you about today is what I think is the awesome task before us in child welfare cases, which is how do we design a system in which we can take people who are probably at the worst moment of their lives and try to persuade them to engage with us, to motivate them so that they have confidence in our system so that they want to work with the agency, the court, and the lawyers to get their children back, which is the heart of what procedural justice is all about. If you take a step back and think about child welfare cases, they're sort of different than any other type of case in that most civil cases or criminal cases deal with just figuring out whether someone has done something wrong or not. Child welfare cases really has a little bit of that element, but really the heart of what we do is future looking, which is we're concerned about whether abuse or neglect occurred, but really the heart of our work is how do we heal this family? How do we address the issues that led to the court's jurisdiction? And to do that, we need to design processes that really treat families with respect, which is the core of what procedural justice is all about. So what I want to talk to you about today is first some of the basic elements of what procedural justice is, and then talk a little bit more about how our systems fall short of that, and some of the things you all might want to think about as you assess your jurisdiction and how you do on elements of procedural justice. So fortunately for us, a lot of psychologists have studied the issue of procedural justice, and they've identified key values that litigants look to determine whether systems are fair and just. Right? So the heart of issues involving procedural justice is first, trust and motives of authorities. Right? Do litigants, when they're in court, believe that the lawyer, the caseworker, the judge are all being fair and have motives? Right? So when a judge or a caseworker says, I want you to reunify with your children, do they really mean it? Do their actions comport with their words? Are they consistent? That's something that the research shows that litigants look at. Second, and perhaps most importantly, is do they utilize fair procedures in their decision making? So you might ask yourself, then what is fair? What's a fair procedure? And the research tells us several different components of what litigants look to when determining whether something is fair. So first of all, they look at whether individuals and litigants are able to fully present their arguments. This concept of voice is central to the issue of procedural justice. Does the individual feel like court is a place where they can tell their story and be fully heard by those that are making decisions? Second, can litigants, parents, others, feel like they have some control over the process, or are they simply bystanders? What the research tells us is the more control someone can have or feel that they're having over the process, over the decisions that are being made, the more likely it is that they'll feel like the process itself was fair. In contrast, the more that court or at an administrative hearing or a meeting is perceived to be something that the others are doing without giving individuals a chance to really have input, the less likely it is perceived to be fair. We talked about the opportunity to be heard. With that is the opportunity to tell a story, the opportunity to give people, even when the story may not affect the ultimate outcome of the case, just that simple opportunity, giving people space to talk about what they've been through, where they want to go in court, is something that litigants find valuable. Adequate legal representation. This is a big one as it relates to procedural justice. The idea that for people to believe that the process is fair, they need to feel like their attorneys were zealous on their side and working on their own behalf. Neutral decision making, really this understanding that the decision maker before you is neutral, unbiased, isn't favoring one side or the other, is treating everyone equally. And with that is the notion of treating every person with civility, with respect, sort of reaffirming that every single person but in the court is treated equally and is treated with a basic level of humanity. And then finally, making sure that everyone understands what's going on in court, right? So we have court hearings where so many different and complicated concepts are being discussed. The issue with procedural justice is making sure that every litigant who leaves that courtroom has a very good understanding of what is going on and what just happened. Satisfaction with the process is crucial because the research tells us that the more people think that the process is fair, the more likely that they're going to comply with the mandates or orders of a court, regardless of whether they actually agree with what the judge ruled. And again, in our world, this is so crucial because there's a forward-looking element, right? So certainly in like a criminal case, it's important for the person to comply with the components of probation. But here, the future of this kid's life and the idea of whether reunification, which is the heart of our system and its goals, is tied to this forward-looking element, to how much the parent is willing to engage in the process. And what I think we have learned over the years is how we make decisions is centrally related to the likelihood that a parent is going to cooperate and engage with the agency in a productive and meaningful way so that the case can move forward. So here's your challenge, right? So your challenge is to think of your jurisdiction and think about how on these different measures do you comport with basic measures of procedural justice, right? So where can you strengthen your systems as you think about how to involve families and parents in your system? And so what I want to do now is just highlight some of the challenges across the country that folks have been struggling with as it relates to procedural justice, because it may or may not affect the way that you think about your own systems. So first, we mentioned that a key part of procedural justice is the right to counsel. Yet what do we know is across the country, we are failing in this basic mandate to ensure that everyone, every parent, every child coming before the court system has access to early counsel immediately upon the filing of the petition, if not before. We have states still in this day and age that don't appoint counsel for parents until the termination of parental rights stage or later on in the proceedings. We have many other jurisdictions that don't appoint counsel for parents at that first removal hearing, instead waiting for weeks or months while the parent is forced to navigate the system on their own. As you think about assessing your jurisdiction, you need to think about where your state lies in this continuum. Because what we know, again, is that without adequate counsel, that litigants, rightfully so, perceive systems to be unjust or unfair. And with that, even if you're in a jurisdiction that does appoint counsel in a timely fashion, you need to think about what type of counsel your system is providing to parents. Is the counsel adequately compensated? What level of training do they receive before they accept a case? What level of training do they receive on an ongoing basis? In other words, what are you doing as a jurisdiction to make sure that the lawyer who represents that parent is a lawyer that we ourselves would want if our child was placed in foster care? And what I fear is that the answer for many of us is we wouldn't be satisfied with the level and the quality of counsel we are providing to families within our system. And if that's the case, then we ourselves shouldn't be surprised when parents in the system are frustrated with the processes and refuse to engage with agencies and with courts. Second, as we think about our systems, we need to think about how much we rely on third parties to provide input in decision-making before we even inquire of families what's best for their children. One of the good things about child welfare over the past 30 to 40 years is we've become professionalized in that we have many, many professionals working within the system. One of the bad things about child welfare in that same time period is that we've become professionalized, meaning that we often look to folks like a guardian ad litem, like an agency caseworker, like a parent's attorney, like a court-appointed special advocate, to opine on what's best for a family without first asking the family themselves what's best for them. And so if you think of the appearance and the message this sends to families within our system, it is one that your voice doesn't matter. That if you're a child in foster care who's aging out, that we'd rather ask your GAL what's best for you rather than talking directly with you. Or you're a parent at the dispositional stage of a case, figuring out what services are that your family needs to get back together. And we ask everyone in the room before we look to you, if we do that at all, to figure out what may be best for you. And so as you think about your systems and how your court hearings are structured, think about what voice and what opportunities you're giving families themselves to directly provide input into the creation of the plan to reunify the family. Do you give an opportunity, and this goes hand in hand with providing input, do you give an opportunity for the parents to tell their story? And if so, how are you doing that? And are there ways to deviate from the traditional adversarial system to give some space in court or during administrative meetings for parents and children to get an opportunity to talk about what they've been through, and for judges to hear what they've been through as they think about case planning? Respect, right? Thinking about the words that we use to talk about parents and children in the child welfare system. How do we call a parent? Do we call them in court birth mom or birth father, or respondent, or mom and dad? And if so, how would we feel if people refer to us in the same way? One of the stories I tell with my law students to make this point is how would they feel if I'm talking to another lawyer and I refer to the law student simply as the student or the law student, as opposed to by what their name is. Simple changes like that can really send a strong message to parents that they are valued. With the idea of respect and voice comes the idea of truly engaging parents in the process. We talked a little bit about court. This applies at administrative meetings as well, like family team meetings. One of the great trends in child welfare in the past decade has been this recognition that we need to involve families more in decision-making through family team meetings, group decision-making, the idea being that families should rise to the forefront. Wherein we have failed is the implementation of many of these concepts, where so many meetings are held where the family, even though in name the meeting is meant to give families a voice, families are pushed to the side and the professionals take over. So not just in court hearings, but also in administrative meetings, we need to make sure that the families lead the way and that their decisions and their views on different issues are respected. And not just in meetings. I think that procedural justice, another way of incorporating that, is figuring out ways to involve kids and parents in ongoing activities outside of court as well. Are there school meetings? Are there doctor's appointments? Are there other issues, sporting events, where we can involve families and let them be a part of their children's lives? Because the more we can do that, the more that they will feel that they have a voice in the process, that they're involved, that they can provide input, and really that they feel like they are parents to the child, that they're not just there as bystanders. Too often we expect reunification is going to happen with this process of someone else stepping into the shoes of a parent during the actual case, and then we completely disempower the parents as if they are no longer in that role, and then we magically expect them a year, 6 months into the case to step up and step back into that function. What we need to do if we want them to engage is really have an active amount of engagement throughout the entire process, from the beginning, even while a kid is in foster care. And if we do that, you will find that parents will feel much more satisfied with the entire process. Because again, it all relates to the idea that they'll trust our motives. If we see that that we're not trying to strip them forever of their rights to parent their children. Two more points about how you might think about your systems and where you might want to strengthen things. First, understanding. Right? Do the parents understand what happened in court? what I hear, I do a lot of work talking to parents across the country, and what you hear over and over and over again from parents in the system and kids is they had no idea what happened in court. And these are court hearings where parents were fully represented, kids had counsel, but they still lack basic sense of what the decisions were, what was ordered of them, what was asked of them, what the judge decided, and they're leaving the courtroom confused. And again, linking it to the research, if this confusion exists, the perception of our court system as being a place where fair decisions are being made will really be undermined. And so we need to make sure that court systems, and this falls on the shoulders of many, right? It's not just the judge, but the lawyers, the caseworkers, the court staff. What are we doing to make sure that the families before us understand what's going on? And this is where I think that court systems can be incredibly creative, right? So the idea that we all know that people learn in different ways. It's not just people absorb information in different ways. Some of us learn visually by things being written down on a big board. Some of us learn in an audio way where information is spoken to you. But in court, if you think of ways that traditional court proceedings are set up, it's completely verbal, right? Things are said to you, and then you walk away with an order. And honestly, in most jurisdictions, the way that court orders are structured are completely incomprehensible, even to lawyers, because they have lots of boxes checked and lots of form language, and they're not incredibly helpful. And so what are you doing in your jurisdiction? Is there ways you can make this more creative, right? Could you set up a whiteboard or a computer screen, where you can type in information as it's being presented in the court hearing, or summarize the order and the services that are being required and put it on a big screen so that people can really see what's being asked of them before they leave the court process. This is the type of creative thinking that I hope that you'll engage in as you work in groups and talk about your small jurisdiction, because again, each jurisdiction is going to have a different challenge in terms of how to move forward. And finally, and this is, I think, a big issue, again, across the country, is if one of your goals is really for your system to be perceived as fair, think about how you are enforcing the procedural rules that are written in your statutes and your court rules. I think that there's nothing, or very few things that are more frustrating for a parent when they're told by their lawyer, well, this is the process, this is the law, you have the right to present evidence, and they get to court and they're told, that's not how we do things down here, regardless of what the law says. I think that one of the basic steps that we as a system need to take in order to get people to believe in our system is to follow the law, to enforce the rules fairly amongst all the different sides, and really to send the message that the law matters and that the court is going to hold all parties accountable and responsible for following these legal mandates. So the challenge is up to you, right? So now you have to work with your jurisdictions and figure out what am I going to do and how can we make sure that our systems live up to these high ideals. In doing so, I would really encourage you to talk to parents, talk to kids, talk to lawyers, get a first-hand perspective on what the consumers of our system are experiencing as they navigate this process. Listen to those concerns, involve them in the process, and then start taking small steps. For many of you, you will look and experience this as a pretty daunting task because some jurisdictions, unfortunately, have a long way to go. But again, success comes in small steps. Figure out one thing to work on. And I think that if you do that, and you take one small step, whether it's referring to parents, by their names, whether it's appointing counsel in a timely way, whether it is giving parents a voice in court hearings and an active role and sending the message that their views matter, whatever it is that you choose, it will be a step towards ensuring that your systems comport with basic notions of procedural justice, and it will increase the likelihood that parents will comply and cooperate and engage, which is at the heart of our child welfare system. So thanks for listening to me, and I wish you the best of luck.